our chairman, council members, fellows and colleagues in the HR profession, good morning and a warm welcome to all of you to our 5th HR webinar series with the theme Coronavirus in the Workplace, the Strategic Role of HR. Now, although the arrival of the coronavirus in Kenya was inevitable and had been foretold since the beginning of the year, it is fair to say that when it finally hit the country in mid-March, employers and employees alike were ill-prepared for its full impact. Suddenly, and almost in a movie-like fashion, most businesses were shut down or began to operate within limited hours. Thousands of workers were sent home on undefined terms, while for others, the concept of working from home was viewed skeptically. Now, it's become the new normal. As the countrywide dusk to dawn curfew followed and talk of a total lockdown became even louder, the implications of forced leave and massive layoffs without compensation became the most frequent questions for every company lawyer or HR profession. The COVID-19 emergency has laid bare various gaps in Kenya's labor laws, which need to be addressed through legislative reform. It also challenges employers to review their employment contracts and human resource policies to mitigate some of the risks exposed by the pandemic. So to unpack this topic for us, allow me to invite and to welcome Advocate Steve Ogolla, who will then be speaking to us about the impact of COVID-19 on employment law, OSHA, as well as HR compliance. Steve, karibu sana to the HR webinar. The platform is now yours.
Thank you so much, Rose. This is Steve Ogolla. I'm an advocate of the High Court of Kenya. I practice here in Nairobi. My firm is located in Upper Hill, just opposite Capitol Hill Police Station, next to the ODPP. Then if you know where the ODPP new offices are, we share the fence with the DPP, Nordin Haji. Just again, by way of introduction, yes, I have spent a lot of years, 6 years, working on human rights and governance issues. And as I always say, that there's a lot of interconnectedness between employee rights and the broader connection of human rights generally. For now, I run my own practice. It's a full service practice that covers all broad areas, including employment law, constitutional law, judicial review, criminal, anti-corruption, and so on and so forth. Just the usual litigation work. I'm glad that I was given an opportunity when Rose spoke to me and invited me to this webinar. I was excited because this is an issue that everyone is grappling with, the employers, the employees, government, and other stakeholders. And we all want to have an amicable solution or settlement to the issues that may emerge during this period. So having said that, the purpose for which you have convened here is to explore this issue on the impact of COVID-19 on employment law, OSHA, and HR compliance. So I've prepared a presentation, speaking notes, if you like, on learning the right lessons from COVID-19, resolving the employer's nightmare. So I have I've marked this presentation to last 15 minutes, the initial 15 minutes, and then make it more interactive. So in the first 15 minutes, what I'm going to do is to take us through what I consider as the salient issues. Rose, could you please confirm to me, since this is audio, I don't know whether we are still there.
Yes, we are. There are questions and comments coming in,
yeah,
so please,
fine.
you're not speaking to yourself.
And I just needed to be sure, because now, so I'm starting the presentation now, and I've said that it's going to take just about 15 minutes to give us an overview. Then now we can engage, then I can come back again. So what are the right lessons from COVID-19 that employers or HR practitioners can learn to resolve this nightmare It is a nightmare because we had not anticipated such abrupt disruption in the flow of work. So the first thing I want us to be alive to is what I call the general principle. After I've given us the general principle, I'm going to take us through what I consider as necessary measures in light of the circumstances. When I talk about necessary measures, I mean what needs to be evaluated and what interim measures need to be taken. And then I'll have a small conversation around changes in the employment contracts as part of those interim measures that need to be taken. And then I will talk about necessarily, because in any employment relation, you cannot ignore the question of termination. What should happen in the event of termination of employment during this COVID-19, or for reasons relating to COVID-19 after COVID-19 has ended? And what does the options look like in a court of law? Because I'm a practitioner. So as you can see, those are just three broad areas: the overriding principle, the necessary measures, post-COVID-19 adjustments. So those are the three broad areas. So now on the principle, what we have to remember is this: new terms and conditions of employment, because certainly we're going to have new terms, as you will see. New terms and conditions of employment, terminations and other matters arising out of employment during COVID-19 must guarantee equal and fair treatment of employees, which means whatever you do, you must ensure that there's fair treatment, equal and fair treatment of employees in the circumstances. You understand? So the second thing is on the necessary measures. Now that we agree that whatever measure we take, whatever action or whatever innovation we take as part of the response to COVID-19 pandemic, we will ensure, or we will test it against non-discrimination or equal treatment of all employees in the circumstances. And when I was speaking with Rose, I said that what is equal and fair treatment is what matches common sense. You ask yourself, what would common sense require in the circumstances? And then you implement it. And you implement it in a consultative manner. So then some of the necessary measures that must now be taken as you respond to this crisis includes now evaluation. Evaluation will happen at 4 levels. First, you will evaluate, you will review the employer's operational requirements. What are your operational requirements in the context of COVID-19 to be able to function as an office? Secondly, you will have to identify critical resources or personnel that are necessary to keep the office running at the very minimum. Thirdly, you'd have to evaluate each employee's functional capabilities or capacity in the circumstances, because some may not be able to continue working because of the measures the government has given, and some may be necessary that you continue having them in the office or in some other place. Lastly, you may need to realign HR policies and procedures and the code of conduct to reflect the changing circumstances, because remember, these are still your employees. Whether they are working from the office or working outside the office, whether they are not working, they are still your employees. Until lawfully terminated, they are still your employees, and you must be able to hold them to account for the time that they are spending. Now, this process, as I've said, should be as inclusive and as participatory. So I've talked about what needs to be evaluated, the 4 critical issues that need to be evaluated: your operational requirements, identifying of critical resources that are necessary to meet your operational requirements, evaluating every employee's capacity in the circumstances, and then realigning HR policies and the code of conduct. if you don't realign them now, you may not be able to realign them post facto and rely on them. And I think I'll explain that later. Now, I've said, even in this evaluation, try as much as possible as a HR practitioner or as an employer to ensure that it is as inclusive and participatory as the process can get. Now, what are some of these anticipated changes that you may make during COVID-19? We're talking about now innovation within the law. The first one, of course, recalibration of employment relations must happen in the circumstances that what you have now. But I have identified some questions, about 10 questions, which I call as organizing questions, to help you frame the anticipated changes that you intend to make. And I'm sure you've already made some of those changes because this is now more than a month since COVID-19 was declared a national pandemic and an emergency. The first question you should reflect on, or you ought to have reflected on, is the question of which of your employees are critical resource in the circumstance. The second organizing question is which of these employees are non-critical resource in the circumstances. The third question is, can the non-critical resource take leave of absence or work on rotation? Fourth question, is the employer in a position to pay part or full salaries during this crisis? Number 5, if employees are on a pay cut or unpaid leave of absence, what is the rational justification on a case-by-case basis? Why that particular employee, or why all employees should be on a pay cut or should take unpaid leave of absence? Number 6, what safety measures can be taken to ensure critical resources can work from the office? What adjustments have you made to ensure that those who must work from the office are safe? Number 7, what viable measures can be taken to ensure critical resources work from home? If they must work from home, what measures will you take? Or is it just as simple as telling them work from home? Number 8, what measures can be taken to ensure effective coordination and/or supervision of employees on duty, whether they are working from home or whether they are working from the office on rotation? It presupposes coordination and supervision. Now, number 9, in case of an exceptional circumstance, what interim measures can be taken to ensure fair treatment in case of termination, suspension, or disciplinary action? We do not foresee, and we hope that we don't need to fire employees during this time, but is the employer truly stranded that if they needed to fire, they may not be allowed to fire, or can they still fire employees if they are pushed to that level? Or put differently, can an employee resign also? So those issues, they may not be considered as core, but they're also part of management that you really have to reflect on and have an idea, so that if you're confronted by a situation like that, at least you have an idea of what to do. And then lastly, number 10 is, what is the implication of the COVID-19 bill, or what Parliament is calling the Pandemic Response and Management Bill 2019, on the measures outlined above, on the measures you intend to take at the office? Have you reflected on how this bill that is being debated in Parliament will impact on those measures? Because after that bill is passed and made into law, some of the measures you've taken so far, you may need to realign them so that you're not in breach of that law. Or if the law proposes some measures that are unimplementable, then you may need to say so when there's still time, or at least record them. So now, having brainstormed on those anticipated questions, on the organizing questions, you may now need to make some interim measures. So we will compare what interim measures you have taken so far, or what interim measures can be taken in light of the circumstances. And I've outlined 3 main interim measures, taking into account all the questions that I've raised, the 10 questions I've raised. Implementing interim measures should be effected through, number 1, addendum to employment contracts. Outlining mutual agreement, and emphasis is on mutual agreement to vary terms and conditions of employment, because employment is a contract. A contract presupposes that parties agree to it. Measures to be taken, outlining, you do an addendum to the employment contract, outlining mutual agreement to vary terms and conditions of employment for a duration to be specified, subject to future review. So maybe as you listen to this, you may need to reflect on your company and your organization. Did you send your employees on unpaid leave without consultation? How was it communicated? How was that decision made? Did you do an addendum? You know, so, and what can you do now to correct any error based on an oral agreement, which is intended to cure a written contract, to adjust a written contract? Because the law is, documents speak for themselves. And where an employer has a written contract, to change that, to change the terms or to vary the terms in that contract, you need an addendum signed. Otherwise, the court is duty bound to stick to what is formally documented. Now, what will you be varying in that addendum? You'll be in that contract. If you prepare an addendum, you'll be varying, of course, the hours of work, the place of work, and the remuneration. Those are the 3 areas. You may vary more based on the need of the company, but certainly hours of work, place of work, remuneration will be varied. Number 2, on the interim measures, every employer or every office now needs a COVID-19 HR policy and procedures. It's very important that even if you don't have COVID-19 HR policy and procedures, that you move with speed and draft these procedures and find ways of sharing them for input in the usual manner of preparing policies and procedures. Because you may be placed in you may find yourself in a position where you have to rely on those policies and procedures during this time to make a decision. And then lastly, number 3, on the measures, you may need COVID-19 employee code of conduct. Because now you find yourself in a position where employees are working from home. It could be a small thing as discipline. You have a Zoom conference, such as now, with your employee. You've set the meeting at 9 a.m. The employees are not available at 9 a.m. How long can you wait? At 10 a.m., they are not available. What can you do? And whatever you're going to do, is it arbitrary or is it anticipated? So it's good to have an employee code of conduct. I think maybe after this session, you may need to reflect along these areas and see what kind of adjustments you may want to make. If you don't have this, the consequence is the court will then, should there be litigation around these issues, the court will then have to determine what was fair in the circumstances. Now, I've said decision-making in the circumstances should be as inclusive and participatory as it can get, to the extent possible. Now, I want to narrow down specifically, and this is more or less like the second last item. Post-COVID, what are the post-COVID-19 changes on employment contracts? If you're preparing an addendum, there has to be a variation clause. Okay, sorry, I've sort of spoken the issue of the addendum. I'm talking about post-COVID-19 changes on employment contracts. If you're able to do all these things, you will realize that after this crisis is over, business or the nature of employment contracts will change significantly. And what HR practitioners and employers need to be alive to, the first one is on variation. Now it becomes necessary that every employment contract should have a clause on variation. I think most employers put those clauses, but there are some that don't put those clauses. You may need a clause now on variation, permitting the employer to make reasonable changes to terms and conditions of employment to meet the changing needs of the business. It makes work easy. Then if you have that variation, then you may not need to do an addendum, because you can just cite that variation and issue a communication. Number two, there has to be a specific variation. I think most contracts, the ones I've seen and the ones I've prepared, usually has a place of work. But the significant change now in the place of work, now there's need to be a clause there that says the employer reserves the right to vary the place of work as may be necessary to meet the changing needs of business. So which means that after COVID-19 is over, we may need to innovate, and there are things that will never be the same again. So the place of work will not necessarily be the physical address where the office is located. Depending on each employee's need, the technical capabilities and the job description of each employee. Thirdly is on the hours of work. Some employers allow flexi hours, flexi hours. Most contracts say 8 a.m. to 5 p.m. with 1 hour lunch break, because that is what the Employment Act provides. But you may need a clause there that gives the employer the right to reserve, to vary the hours of work as may be necessary to meet the changing needs of the business. Then the fourth issue that will have to happen after COVID-19 is you may need to reflect now on all your employees that their contracts on privacy and data protection. Data protection, even now, during this pandemic, is a shared responsibility. This should be a shared responsibility between the employer and the employee in safeguarding sensitive data in the circumstances of variation of workplace. If you urge an employee, if there should be a need, although I'm talking about future needs, but this can even be applied right now, if the employees are working from home, depending on their job description and the task they're performing, what is your shared responsibility as an employer? Because if you're going to require employees to work from home, they may need internet. Who is going to meet internet costs? And that speaks to the last issue. Maybe security. Do they have secure network? If there is infiltration, how will you be sure that this infiltration is not as a consequence of exposure, as opposed to unavoidable exposure, as opposed to negligence of the employee? Then the last thing is on additional expenses. I've given the example of internet. If the employer should meet or reimburse necessary expenses incurred on the organization's business as a result of variations in the place or hours of work. This will have to happen in the future contracts, but it can also happen now. So I've given us an overview. The only thing that I need to highlight maybe in a minute before I allow then maybe engagement, what happens in case of post-COVID-19 termination of employment or termination of employment in the middle of this crisis. Now, if it should so happen that an employee should resign or be terminated, you need to be, I'm sure all of us are aware, most of us are aware about the full scope of termination on fair reasons as the circumstances may require. Every time an employee is terminated, every time you fire an employee, the test is always fair reason, termination on fair reason. Every employer has a right to terminate, but on fair reason. what are fair reasons in the circumstances? You have to define fair reasons in the circumstances of COVID-19. Usually there are about 7 reasons, so 7 grounds why an employee may be terminated. I'm sure all of them, we are familiar with all of them. I don't need to overemphasize them, but I can list some of them. I can list them. An employee may be terminated because of their conduct, competency, incompetency, incompatibility, redundancy, insolvency, the company is getting dissolved, effluxion of time, the contract has expired anyway, inability to work due to operational requirements. So these 7 reasons, the conduct of the employee during COVID-19 period can trigger termination right now or even after the pandemic is over. Incompetence, general incompetency. Maybe there's an employee you've been monitoring for a while and you're not satisfied with their output or targets, and you think they are incompetent. Can you fire them now, or do you have to wait until COVID-19 is over and fire them? And of course, compatibility means your ability to, in terms of interpersonal skills, ability to gel with other staff, ability to take instructions, ability to just be co-opted into the organizational culture. This can also lead to termination. It's a fair reason for termination. It could also play during this time, redundancy. You may declare an employee redundant. Although I'm going to tell you later, maybe as I finalize after this session, that's a measure I would probably hesitate to recommend because this is a passing cloud. Insolvency is also depending on if the company is unable to recover completely. Effluxion of time. Some employees are on contract and the 5-year contract, 3 years contract, and it's coming to an end and it's not going to be renewed. And then, of course, inability to work due to operational requirements. Maybe there's a significant change in circumstances, how the company will be working post-COVID 2019. And those changes will then now render some employees, the position will be there, but the changes will come with additional requirements that will render these employees unable or unsuitable to continue holding those positions. Now, all of us know, as HR practitioners, and as a litigation lawyer, I certainly know this, that employers usually have no problem with the first 4 reasons. They will always, employers usually have no problem, sorry, I was getting a slide which is not on what I'm reading. The first 4 reasons on conduct, termination on misconduct, incompetency, incompatibility, and redundancy may always be disputed by an employee. So you always have to be alive to that. So you have to ask yourself, if I'm going to terminate an employee during COVID-19 period, or for reasons related to COVID-19 crisis, whatever is happening during this period, but you're terminating after COVID-19, the employee is likely to challenge that because it's the nature of employees to challenge termination of employment if the reason for termination relate to their conduct, relate to their competency, relate to their compatibility, relate to the redundancy. Usually an employee will not challenge termination based on insolvency or effluxion of time, or maybe inability to work due to operational requirements. But this provision on the law on inability to work due to operational requirements, when I check the case law, I find that it has not been tested, at least not robustly. Maybe this COVID-19 will present an opportunity to the courts to test what it means, or to test the law on termination for inability to work due to operational requirements. Maybe you've made some changes, so the position is not redundant, but it has now enhanced requirements that now excludes the current office holder or the employee that is currently performing that task. We have not had such a situation, but it could arise as a point for litigation, but you need to be aware with it. To be familiar with it and aware of it. Now, you also need to be aware, and most of us are already aware, and this is really truly the last thing. If an employee should sue an employer, what are the kind of claims or awards that may succeed in court? So that you work backwards on those issues. Because as sure as the sun rises in the east and sets in the west, or for Christian believers, as the Christian believers would say, as sure as Jesus is Lord, there will be litigation arising from this COVID-19 based on how employers have handled employees. So you just need to be ready and anticipate that. Here's a broad range of possible awards that may happen on case by case, office by office. Employees like asking for salaries in lieu of notice, if you should terminate them without notice. Number two, unpaid salaries earned. If someone is getting terminated on 20th of the month, the 20th day of the month, work done from up to 20th. Number three, salaries withheld while on suspension. If you put someone on suspension without pay and the court found that the suspension was unjustifiable, they will ask for that salary. Unpaid days worked, unpaid leave earned, unpaid allowances, compensation for unfair termination. I'm sure we are aware about this. This one initially not more than 12 months gross salary. Number 8 is on service pay. Service pay is rarely awarded for those who are on NHIF, or those who are on a pension scheme or NSSF. Severance pay, again, severance pay only in the case you have declared an employee redundant, is 15 days pay for every year worked. I'm sure we are familiar with that. Gratuity, that is usually, it must be in the contract or in a CBA. So that is a general overview of what challenges exist and what employers and HR practitioners need to adjust to so that employees are protected, but the employer is also protected. And the business is also protected, because you need the business after this COVID-19 is over, you need the business to continue running. So all the innovations that you must make, the rule of thumb, if you must forget everything, for lack of a better word, the rule of thumb is that whatever measure you are taking, is there a rational explanation for it? That is the rule of thumb. And is it fair in the circumstances? If you can achieve the 2-test standard, then you will not have a problem, whatever may arise. Can you provide a rational justification for the decision that you're making now? And is that decision fair in the circumstances? Now, it doesn't matter what the question may be. Whatever issue that may emerge will be tested against those 2 standards: rationality and fairness. So I think I can pause at that point and allow engagement, because I was giving a general overview, and I don't know our backgrounds, where we work, our offices, the nature of our needs. So with this general overview, it's possible that some of the issues I've raised have been answered. It's possible that the questions that you hope to be answered have not been answered. So then you can put them to me directly, and then we can engage. Ross.
All right. Thank you very much, Steve, for the insights. I think a lot of the questions that are coming up are to do with salary cuts. How do we go about determining what the cuts should be? What happens in the event that an employee doesn't assent to a salary cut? And in the event that you have unionized employees, should you then be having a conversation with each of them, or do the union representatives suffice for purposes of undertaking the salary cuts?
Okay, maybe repeat the questions, that we go one by one and I give brief answers in about 30 minutes to each question, so that I don't skip any.
So salary cuts, how do we go about implementing that?
As I've already said, salary cut is a necessary consequence of reduced revenue. If you have experienced reduced revenue, you have to explain to the employee he has to agree to a salary cut as a necessary measure.
So in the event that an employee doesn't agree to it, what options does an employer have?
Then there's a dispute. If an and how to resolve the dispute will be solved, or a stalemate, how to resolve it. If you don't have an amicable agreement on how to take a salary cut, then the first option is for the employee to resign. If the employee refuses a pay cut, declines to resign, then you can terminate, because it's an agreement. You see, you hire an employee because you have the capacity to reward the effort put in place. If you don't have the capacity to reward effort, then you have to explain it. If the employee is too expensive, you have to release them and then get another employee that can take a pay cut, that can take a lower salary. What is unacceptable, because what the court will evaluate is this. If you fire an employee who has refused to take a pay cut, when there's a good reason for taking a pay cut, then you hire someone in that position on the same scale, in the same circumstances, then now you run the risk of being accused of unfair termination, or terminating someone for some collateral purposes and not necessarily the pay cut.
Okay, and what happens in the event that you have a union representing various cadres of employees? Do you have a conversation with each of those union members, or is a conversation with the union representative sufficient enough to then warrant the salary cut?
If you have a CBA, depending on how your past engagement with the unions will be, if an employee is part of as a beneficiary of a CBA, then you alert the union leaders. But you can also just communicate to the employee. The employee will then communicate the union.
Okay, so you talked about the COVID-19 HR policy. Others are calling it a crisis management policy. What are some of the things that the policy should be able to address?
I already outlined some of them. The policy should be able to take into account 3 issues. 1, what do you do with employees that now have to work from home? And what do you do with employees that have to work from the office? And what do you do with discipline issues or the usual HR concerns? Because that is what is in the HR policy and the code of conduct, employee code of conduct. Just making necessary adjustments to ensure that the organizational culture, organizational material and business secrets are preserved, discipline is preserved, and avenues for resolving disputes are also preserved. So any HR policy will outline, for instance, if you're working from home, what do you need to do when you're working from home? And what does it mean in terms of responding to your supervisors and superiors if needed? And what happens if you don't respond to them? So basically, just you look at your existing policy, HR policy or procedures, and reinterpret them in the context of the present circumstances. So perhaps maybe a better way would be to go case by case. You give me an example of a particular HR policy, but generally that is just how you go about it. Look at your HR policy as it is now. What does it say in regard to this employee or to employees generally? How do you interpret this or implement this if employees are not in the office? For instance, arriving in the office late is unacceptable in any place of work. But right now, employees won't be arriving at all. They won't be arriving at all. And the idea of arriving early is so that they meet their targets. So how do you adjust that so that to ensure that if somebody has a target to send by 5 p.m., some assignment to send by 5 p.m., they send it at 5 p.m. And they don't, unless now they have an exception, there's an exceptional development where they can't send it, which can happen even in the context of office setting, then you know what to do. So you make adjustments based on the existing HR policy. You read it, you ask yourself, how am I going to adjust this clause or this provision?
All right. The next one is around disciplinary matters.
Yes.
Can we have disciplinary cases resolved via Zoom? And in cases where you had disciplinary issues before COVID-19, are they still relevant for you to be able to handle them now without looking like you're victimizing people as a result of COVID-19?
The way to go about it, the ones disciplinary matters that can be deferred until the crisis is over should be deferred. The ones that can be, but should be notified, the employee should be notified and then deferred. That we've noted this, but we'll handle it after the crisis is over. But the ones that can't wait, then you have to innovate. I mean, I have done hearings, court cases, right here in my house, without having to appear in a court of law, because the case was really urgent. But I have cases before the judges, the various courts, all the way to the Supreme Court, the Court of Appeal, the High Court, and the Magistrates' Courts that are important, but are not extremely urgent. Those ones, I have advised my clients that the judiciary has said those cases have to wait. All the cases that were to be determined in March and part of February, and even now in April, have to be deferred to a future date because of the circumstances in which we find ourselves. But should there be an exceptional circumstance of a matter that cannot wait, then that must be resolved in whichever way possible. So all you have to do is you have to ask yourself as an employer or as an HR practitioner, if I should resolve a problem, what kind of necessary innovations in the circumstances do I need to make? Does this employee have Zoom? Can we do this via Zoom? Do they have internet connectivity? If they tell you that they are unable to connect to the internet because they don't have internet in the house, then you have to wait. Unless you're paying for that internet, or unless they are willing, you can't force them to say, we're going to have a disciplinary meeting via Zoom. They will tell you, I don't have internet connectivity in my house. Then you can't make a decision until then you defer the matter. But if they are happy to, or maybe you gave them allowances, like most employment, some employers give employees airtime allowance. Maybe at this time you may give them some allowance to buy bundles, or maybe to connect to internet service providers like Safaricom, Zuku, and so on and so forth. Then now they would not have a reason not to proceed. So it's about innovation. It's about mapping out what is urgent and important. What is urgent and important cannot wait, must be resolved now. So we found out ways of resolving it. What is important but not urgent, we can take note and resolve it after the crisis. Yes.
Okay. A few questions around OSHA. Perhaps just touch on some of the things we need to be cognizant of.
Well, I think OSHA right now, from what we discussed, the preliminary conversation we had yesterday, it's all about employee safety. Employee safety, ordinarily, you would not care what an employee does in their private places of residences. But if they should now work from home, the first thing that you must evaluate, the kind of tasks you're asking this employee to perform while at home. What are the exposure? What are the risks involved? What are the health and safety concerns that may arise ordinarily in this line of work? Because you know them. And what are the ordinarily, what are the responses that you usually take, or the measures you usually take to protect the employee? Are those measures capable of being implemented in this context or in these circumstances? If it is not possible, then don't expose the employee, or don't permit them to work in an environment where you cannot assure them of their safety and security, which can then eventually unnecessarily expose the employee. So the bottom line is this: there's an opportunity cost to be evaluated at every instance. If the risk is higher than the benefit, then it's not worth it. Suspend all operations until such a time that the organization is able to resume operations normally. If the risks can be mitigated at a reasonable cost and without exposing, without unnecessary exposure to the employee, then now what we will be talking about is negligence. Because you see, for instance, at our places of work, Ross, every employee is entitled to an hour lunch break. You're not responsible for what happens to an employee during lunch hours if they trip and fall on the stairs as they go to get lunch. That can't be the employee. That can't be the employer's fault. So there's what is called the chain of causation. What is reasonably foreseeable and what you can do to stop that. It's not about chaotic expansion of safety measures or an infinite list of what could potentially go wrong. At one point, you must close the chain of causation. You must say, safety measures end here. Outside this parameter, you are responsible for your own safety. And as I said, again, you apply the two standard test. What is rational in the circumstances and what is fair treatment in the circumstances? Is that a rational move to make? And is it fair? It could be rational and unfair. It could be fair, but not, okay, if it's fair, it's certainly rational. So those are some of the issues. Generally, I'm just giving you an overview of what adjustment you can make in the context of COVID-19 if an employee has to work from home and in the context of OSHA.
Okay. Many questions on the new bill that has been placed before Senate. Some are calling it the Sakaja bill.
Yes.
Others are calling it the pandemic bill. Perhaps just give us highlights around it and what are some of the things that we should be looking out as an institute so that then we can lobby.
Okay. Generally, the bill is a welcome move to organize some of the issues we are talking about, but there are some problematic provisions that I've seen in that bill, and let me just read them and explain to us the aspects that I find problematic and what may not work and what you can do about those provisions. Now, let me get it. Just hold on. Let me just find to. I think section 30. If you read, if you've perused or you've read section 30 of the bill, this is what it provides. It provides that where a pandemic adversely affects the ability of an employer to pay salaries or wages, A, notwithstanding the provision of Employment Act, an employer shall not terminate a contract of service or dismiss an employee. Now, I want us to reflect on clause by clause. I have a problem with that. I have a problem with that because this clause must be read again. This bill seeks to suspend certain provisions of the Employment Act, but those provisions in the Employment Act are anchored in the Constitution. In terms of fair labor practices, Article 41. There's no bill or law that can suspend contractual relationships in a manner that derogates from the core. You can innovate around it, but you can't take away the core. So here's the thing. If this bill proposes that, notwithstanding provisions of the Employment Act, an employer may not terminate or shall not terminate a contract of service or dismiss an employee. I just want to ask a practical sense question, why that provision is may be rendered unconstitutional and impractical and therefore unimplementable, is that if an employee that you've equipped in the manner we have discussed steals from you, will he be fired or not fired? If an employee is accused of gross misconduct, will you keep him there because there's a bill somewhere that says you cannot fire them during COVID-19? As you can see, there are inexhaustible reasons why that provision may not be implementable. I think this provision is merely indicative. It is not dispositive of the issue. And it tries to signal to the employer that it sort of tries to make what I can consider as a moral appeal. Moral appeal. Moral appeal. What is moral is not necessarily legal. Moral appeal means you try as much as possible to preserve your employee's position at their workplace. But it has a corresponding obligation. You understand? There has to be a corresponding obligation on the employee that during COVID-19 pandemic, and for them to benefit from this provision, they will not do something that will trigger suspension or termination. If you look at the Employment Act, an employee that succeeds in a claim for unfair termination, when the court is awarding damages or compensation for unfair termination, the law says it can be up to 12 months salary. The grading, what makes the court award an employee 1 month, 2 months, 3 months, or 12 months monthly salary is also dependable on also on their conduct. If they contributed, you may have been unfairly terminated, but your conduct in the lead up to termination or post termination is such that is also inexcusable in the circumstances, you may lose what ordinarily would be entitled to you as a protective measure. So there's a problem with Section 30, Paragraph A, Section 30, Subsection 1, Paragraph A of this bill. There's a real risk that it may be considered or rendered unconstitutional if taken literally, because it denies and it sort of it undermines practical aspects of termination, what causes termination. But let's look at Paragraph B of Section 30. It says, an employer shall not coerce an employee to take a salary cut. We have to ask ourselves, what is the mischief that this provision intends to cure, and find that mischief? The mischief the law intends to cure is that we don't want employers to put profit over life and over fundamental rights of employees. Just because there's a reduction in income does not mean that employees, that's because there's a reduction in revenue, incomes, or profit, does not mean that employees must take pay cuts. So if you want an employee to take a pay cut, there has to be a rational explanation for that. So what this bill suggests is that you do not coerce an employee to take a pay cut. Now, what does it mean to coerce? Coercing can mean you make a unilateral decision, whether it's the best interest of the employees or not, you don't care. You know, it may be the best interest of the company or the organization or the employees that everybody takes a pay cut to preserve their jobs, but it is so unilateral and it is not explained to the employee. It's just a communication that effective April 1st, you are taking a 50% pay cut. The employee may say no. So to deal with that problem, you have to give a rational explanation why an employee needs to take a pay cut. And let me give you examples of what may be considered as rational explanation. Number one, you are employed to work full-time. Look at your contract. What does it say? It says, place of work is this office, hours of work is 8 a.m. to 5 p.m. with 1 hour lunch break. You work 5 days a week for the entire month. Now you're going to work half day from home. Is there a need now to discuss whether you can take a pay cut or not? Of course there is a need. Now, the circumstances, the second reason could be this company or this organization has a way in which it generates income. For instance, if a company generates income through advertisement, and they have now nobody's advertising, and now they're not earning income, its ability to pay employees, even if those employees were willing to work full-time in the circumstances, will be significantly lowered. So you have to go back to your office. Ask yourself, how has COVID-19 affected your revenue flows? And how has COVID-19 affected the ability of the employee to perform their functions? Then there has to be a conversation with the employee to take a pay cut. The question is this, and I think I already addressed this. If an employee rejects what is considered as a rational explanation for taking a pay cut, what do you do? You've said all these things. There's a law here that says you may not compel or coerce an employee to take a pay cut. You have good reasons why an employee may take a pay cut. You have already explained these reasons to the employee. The answer lies in this. What would common sense require in the circumstances? Termination. Termination is an inescapable reality, because what are you doing with an employee who is adamant that they can't take a pay cut in spite of good reasons or rational justifications? And the pay cut is also fair in the circumstances of their work and in the context in which the company is operating. What do you do? Will you say, fine, I will pay you when I have the money? You can fire, and that's why I had a problem with the first provision, or you can tell them, then you don't need to take a pay cut. We will pay you less 30% of your salary. We are trying to innovate within the circumstances. The balance of 30% will be paid at a period to be determined in your addendum. If they reject that one also, then you go back to option one, you have to fire. Ultimately, as an employer or a HR practitioner, you have to ask yourself, because listen, the court will never interfere with the operational requirements or operational decisions of the company. There is no way the court can make decisions for the employer. It's not permitted in the law. What the court can do is to interpret whether the decision made by the employer was justifiable in the circumstances and the action taken was fair. If the court can reach a conclusion that in spite of this provision of the law, termination of this particular employee in these circumstances was fair, then the court will uphold your decision. The other provision, which is the last thing, it says, if an employer is unable to meet his obligations to pay salaries, the employer shall permit an employee to take leave of absence and work without pay for the duration of the pandemic. So there's some escape route there. But I think this provision was not well thought out, and I understand the pressure of making this law. Parliament is proposing an escape route where you can't compel an employee to take a pay cut and you can't fire an employee, but you're unable to pay them. Parliament is telling an employer, then put them on unpaid leave at home so they don't have to work. You understand? But is that provision exhaustive? The answer is no. This employee that is refusing a pay cut could be very critical to the services that you need to render. Yet, you don't have the money to pay him per scale. You ask yourself, despite the provisions, now there will be another proviso there. So what the court will do, if there's a dispute, the court will interpret the circumstance of that particular employee. Was he an essential, was he a critical employee necessary for the company to run during this COVID-19? Was the company in a position to pay him? If the company was not in a position to pay him, did the company advise him on the inability to pay him the normal way? Did the company provide some halfway measures that since your work has not been affected, like for instance, doctors are working full-time. So I don't expect a doctor to come to me and tell me, Wakili, we were put on half pay, or we are asked to take a salary cut, yet I'm working full time. What is acceptable in the context of a medical practitioner or a healthcare worker in the context is that if the employer has run, like for instance, the county government, or maybe these private hospitals, if you have run out of money because of COVID-19, but these are you're providing essential services, you can then reach an agreement. You take a pay cut, but whatever you are forfeiting for now will be paid later. Or you take a pay cut so that the business can be sustained because you also need a job. But then you have to put that in the addendum. I think maybe if there's more clarity, you can ask after this. But that is the point. The other provision is section 29, but this one doesn't really, it's not relevant to us. So COVID-19 management bill, or as it is now known here as the pandemic bill, has serious gaps that will require interpretation. So I would urge employees not to jump into those provisions and rely on them wholesomely without caring to attend to their specific circumstances. And I would also urge employers not to be terrified or scared that because this provision says you can't fire an employee and you can't compel them to take pay cuts, that the only option is to let them work from home and that you can't do anything else. Even an employee who is on unpaid leave, who is an employee, if you permit an employee to take leave of absence without pay, it means, actually this is important and I'd forgotten it was, if you permit, you have to decide. If you permit an employee to take leave of absence, unpaid leave of absence, then you will not call that employee to perform tasks related to their job description. I think I want that point to settle. If you have asked employees to take unpaid leave of absence, you will then not interfere with that employee for the duration that they're on that leave of absence. Just like the normal leave days. When you take compassionate leave or annual leave or maternity leave or paternity leave or study leave or extended leave or negative leave, whatever kind of leave that you may take, whether paid or unpaid, it is to attend to personal calamities or issues, and during that time, the employer should respect that space. The only time an employer can reach an employee who is on leave is if there's an exceptional development that requires that they attend to that matter personally. Then you may be recalled from leave. So I think we take note of that. Employees that have been put on unpaid leave of absence are not expected to do anything in relation to their work, unless there's some development that now requires that they be recalled. And you're recalling them for that specific circumstance. But if you keep on recalling them, then you negate the very reason why they took unpaid leave of absence. And the court will be suspicious of their intention. If you need them to operate, you'd rather tell them to take a pay cut, or you'd rather negotiate with them to work without pay, subject to a condition that within a duration of 12 months, they will be paid. Because many employees do that. There are employees that continue working. And we see it in the news all the time. Nairobi City County, for instance, for a long time never paid their employees. The employees knew they have a right to pay. They demanded those payments. The payments were never paid. What we don't know is whether there was a reasonable justification why the salaries were withheld or why the employer was unable to pay. But ultimately, the employer would have to release those salaries. We all know that. So it's about what is rational, what is acceptable, what is fair in the circumstances. So that is an overview of this bill, what this bill means for employers, Rose.
Thank you very much, Steve. Very insightful, and we appreciate your thoughts. I guess to sum it up is really about, is it rational and is it fair treatment? Whatever it is that we innovate as HR professionals. So allow me to invite our chairman to give a few remarks and also to give his vote of thanks, and then we can proceed from there.
Thank you very much, Rose. And thank you very much, Steve, for that insightful talk today. I believe
Yes.
that all HR professionals are really appreciative of this. And Steve, you've just broken down some of the questions that we've been asking ourselves for a period of time right now on how we are going to treat this important resource. And you've given the practicability, especially starting from the principles. And I want to agree with both what you and Rosa said about the principle number one is about being rational and being fair. And
Yes.
how do we ensure the equal treatment to all employees? That ideally should be our role. And I want to really thank you very much for bringing it down, breaking it in, and even giving us as interim measures, what is it that HR practitioners can do, especially at this time. I think the biggest take home here would be the other documentation that HR people need to lead their organizations to doing, and these include those three main interim measures, just to repeat, and then to employment contract, the mutual agreements on how to vary employment contracts, and the most important, what we call the crisis management policies, or you call it COVID-19 HR policies and procedures. I think those are really practical things that HR people should take into account at this time, just to prepare for any litigations. And I think, as Wakili, you've said, we are certain that there will be litigations after post COVID. Just again, the rest of the things, I think we've had a lot of discussions around the like in the events of the awards, what is it to look out for. But I just want to bring to the attention of our entire fraternity of what we, both as IHRM, as council, and yourselves as practitioners, you need to actually focus on right now. The first, and I think most important and really quite urgent, is what we've just talked about of the pandemic bill. And this bill requires that it affects us directly, and therefore HR practitioners need to contribute to it. We as the council have opened up, and I think ED has already sent out contact line where you need to contribute, give your contributions. I was also touched with section 30, actually the sections that you mentioned, but I do not know, because at times when you draft the laws, there would be the matters of the word shall and may, because again, we have to safeguard our employers as well as employees. That's where we come in as HR practitioners. So the bill is very important, and I would urge you to please follow and give your inputs. And I've already set up a committee that will look at this and make a presentation, and this should be done as early as next week. Number two, you must have seen the Ministry of Labor coming up with some regulations that will guide in the meantime, because we never had this before. And this will greatly affect this, because these policies are the things that will greatly influence your crisis management policies within the organizations. You can see that we are missing out. The Ministry of Labor, and I've already spoken to the PS or the PS representatives who sits in our council about they're focused on two areas. It is COTU, which is basically employees and employee rights, and FKE, who are basically employers. So there is a strong need of HR coming into play and making strong contributions. I've already asked if we can have a meeting next week with the cabinet secretary in charge of labor. But before that is done, we still need your views and contributions so that we can collate and make a good contribution to those policy guidelines. Last but not least is about the way forward, and I will be retreating with Rose and the council again in the next couple of weeks. We'll find a way of how best now do we get into practical ways of handling all this information that we've been given. You realize that most of us, and looking from your questions and contributions, I think probably the younger people in the professions are saying, give us templates, give us, you know. I think we'll get away from templates and all that, so that we need, every individual HR practitioners come up with very innovative way of doing this. IHRM and the council will give the general guidance. Yes, templates would be important in some areas, but let us look at, because the ideas will generally come from you, people who are practicing and who are in the real picture of what is currently, what you're currently handling. So with those few remarks, once again, I'd like to thank you very much, Steve, and just to be sure that we'll still follow up. We have this habit of following up later on with some questions and some areas, and we'll certainly contact you on this, the bill and also on regulations, just to see where that our thoughts do not conflict with either the Constitution or actually the universal human rights issues. Thank you very much. Rose,
maybe just hold on. Before you go, yeah, hello?
Yes, yes.
Before you go, maybe you need to find out from Senator Sakaja, Chairman.
Yes.
Are you there? Just a quick one.
Yes.
Maybe you need to find out from Senator Sakaja,
yes,
on how to improve this bill.
Yes.
Because it has some, in terms of implementation of this bill, if passed into law, I can already foresee some challenges. So it could be improved, amended.
Yes.
Otherwise, if it's not amended right now, then the court will improve it through interpretation.
Yes.
So that's something, maybe that's the first takeaway. Then maybe my parting shot is, whatever the circumstances may be, let's remember the rule of thumb. Whatever you're going to do as an employer or as a HR practitioner, just satisfy the two-test requirement or standard on fairness and rationality. Is it rational in the circumstances? And is it fair in the circumstances? I think once you observe that, we always say that the law is not removed from common sense. And I was telling Rose that even the most complex labor issue or employment question, when it is resolved, it will be resolved in a manner that will satisfy the mind of a 5-year-old child. No matter what. No matter how complex or intertwined the issues are, when they are finally resolved, if you present the solution to a 5-year-old child, they should be able to say yes. Because the law and common sense are interconnected, they're not removed from each other. And as I always like saying, judges or courts are not immune to reason. They will reason with you in your dilemma. And then listen, and then understand what was the best thing that you could have done in those circumstances. So I think that is my parting shot. Yes, I appreciate, I'm open to engagement on this. I saw some people asking for a write-up, but we can take it up later.
Okay, thank you very much, Steve, once again. I'll just be asking Irene, I think she's on this call, to kindly circulate. I can see a few members are asking on the bill to circulate the bill, and also to circulate the regulations that have been drafted by the Ministry of Labor, so that then members can contribute to it. We'll collate all that by next week and proceed. Yes, I'll be having a meeting with Senator Sakaja as well. And one of the areas, I was a bit shy before because I really don't have a document to present to him. So, but after this, I think we'll look at those areas that we feel that we need to make a contribution so that they can amend the bill before it is passed. Thank you very much, Steve.
Thank you so much.
Thank you,
Rose?
Chair, for your comments. And thank you, Steve, as well, for your great insights. We do have a blog, so I'm hoping that you will share some of your thoughts as you have done today on our blog, but we can discuss that offline. So
Yes, that's fine.
Thank you, members, for attending. And we'll see you next Friday at 10 o'clock for our next webinar session. Keep safe and God bless.
Thank you, all of you. Thank you very much.
Thank you.
All right. Bye.
Bye.